believe that this court, federal appellate courts, including the Supreme Court that would be, have the right to review legislation, have the right to declare the constitutionality of legislation. She said, of course, yes, they do, which is any lawyer in the country would agree with. And the president clearly misstated the facts when he suggested that it wasn't the case. And then that's why he came out the next day and clarified, saying he didn't mean to suggest they didn't. The department has not in this litigation, nor in any other litigation of which I'm aware, ever asked this or any other court to reconsider or limit that long-established precedent. Well, of course, it wasn't the department. It was the president of the United States who suggested otherwise. The power of the courts to review the constitutionality of legislation is beyond dispute. The Supreme Court resolved this question in Marbury versus Madison, which is 1803. Our viewers have been hearing that from TV pundits for days now. 1803, this was established that, of course, the courts have the final say on what is or is not constitutional. Only the president ever suggested otherwise and then tried to take that back the next day. Presumptively constitutional. Oh, okay. So now there's part two saying, we also want to remind you that in considering challenges to legislation, acts of Congress are, quote, presumptively constitutional. And they talk about the respect that the court needs to have for the legislature and for laws passed by them. It goes on from there. We'll review it more. Don't want to read you the whole thing, but this is the essence. They're standing by the president, saying his remarks were fully consistent and also making clear what most Americans already knew, which is that the courts do have the power to review and declare constitutional or unconstitutional laws passed by Congress. Greg?
Well, it sounds like they're sort of saying, well, the president was kind of taken out of context because he was speaking in shorthand. But to be sure, Meg, the president lit a legal powder keg when he appeared to claim that it would be unprecedented and extraordinary for the unelected justices of the Supreme Court to strike down an act of Congress, which, of course, as you point out, is the very function and duty of the high court. Even the president's attorney general, Erik Holder, admitted that's not correct. Take a listen.
We obviously respect the decisions that courts make under our system of government, and since Marbury versus Madison, I guess back in 1803, courts have the final say.
Well, it was the famous Marbury versus Madison case, 1803, that firmly established the right of judicial review by federal courts, especially the Supreme Court, something every law student learns. But the president might flunk con law now if you listen to his former law professor at Harvard, Lawrence Tribe, who's a preeminent authority on constitutional law. Tribe says his famous student obviously misspoke. Quote, the president didn't say what he meant. I don't think anything was gained by making those comments, and I don't think any harm was done except by public confusion. Well, if the public was confused, and maybe the president, the Fifth Circuit Court of Appeals was downright miffed, ordering the Department of Justice to submit that 3-page document affirming the federal court's authority to strike down unconstitutional laws. Indeed, the Supreme Court has done it more than 160 times. Now, the White House continues, including today, to try to walk back the president's unprecedented remarks, saying, well, he was just referring to cases involving the Commerce Clause. But when it was pointed out that those cases have also been overturned by the high court, recently in the Morrison and Lopez cases, which, Megan, you pointed out, the White House then parsed it even more by saying those two cases did not involve major economic activity like health care. And so now we see even more parsing in this 3-page document submitted moments ago to the Fifth Circuit Court of Appeals. Megan?
I just want to add a little bit more for our viewers now, having reviewed the whole letter. So again, as I say, they make clear that they believe the courts have the power of judicial review. They acknowledge it's been in existence for 200 plus years. Then they say that power may only be exercised in appropriate cases, and the Supreme Court has recognized that. And then they go on to say, quote, this is Erik Holder, while duly recognizing the court's authority to engage in judicial review, the executive branch has often urged courts to respect the legislative judgments of Congress. These principles of deference are fully applicable when Congress legislates in the commercial sphere. So clearly, the Attorney General is going on to sort of provide some talking points, some context for what President Obama has been saying this week. Not necessarily applicable in his litigation, but then he was forced to make comments in his litigation that he didn't expect to have to make in the wake of President Obama's remarks on Monday. Wow, what a morass. I hope you're following this. We apologize because it's gotten to the point now where, the president commented, he commented again. His White House press secretary has had to comment repeatedly. Now his attorney general has to comment in court because of what the president said initially. And I think the American public is well aware of one thing. The courts have the power to declare laws of Congress unconstitutional.